DWI charges and penalties on Long Island can vary based on the circumstances of each case. If you've been arrested for driving while drunk, it is important to understand the type of charge you may be facing. Speak with an experienced Long Island DWI lawyer before you make any decisions or agree to any plea. Alcohol driving while ability impaired, DWI penalties. A person is guilty of driving while ability impaired by alcohol or DWI if they operate a motor vehicle while their ability to do so is impaired to any extent by the consumption of alcohol. Under the law, a person is guilty of a DWI if they drive a motor vehicle on a public highway after consuming alcohol and their ability to operate that motor vehicle as a reasonable and prudent driver is impaired to any extent. First offense. 1. Mandatory fine, $300–$500. 2. Maximum jail term, 15 days. 3. Mandatory driver's license action, suspended for 90 days. 4. Administrative fees depending on where the offense took place. Second offense. A second offense DWI following a prior DWI or DWI related conviction will carry the following penalties. 1. Mandatory fine, $500 and $1,000. 2. Maximum jail term, 30 days. 3. Mandatory driver's license action, suspended for 6 months. 4. Administrative fees depending on where the offense took place. Driving while intoxicated, DWI, drug DWI, combination DWI penalties. Under New York's laws, a person is considered driving while intoxicated, DWI, if 1. They are found to have a BAC of 0.08% or more. 0.04% and higher for commercial drivers. 0.02% and higher for those under 21 years old. 2. They operated a vehicle in an intoxicated condition. 2. Defined as impairment of the physical and mental capabilities of a driver to operate a vehicle with reason and prudence. A person is considered guilty of a drug DWI offense if they operated a vehicle and 1. They test positive and are proven to be under the influence of a controlled substance, and 2. The drugs or the effect of the drugs impaired their ability to drive. A person is considered guilty of a combination DWI offense if 1. They test positive for alcohol and a controlled substance, or a combination of controlled substances, and 2. The drugs or the combination of drugs and alcohol impaired their ability to drive. First offense. Administrative penalty. The court will suspend a defendant's license while the criminal prosecution is pending if they were found to have a BAC of 0.08% or higher. The court will also suspend the defendant's license if they refuse to take a chemical test. If the refusal is confirmed at the DMV hearing, the driver's license will be revoked for a year and the defendant will have to pay a $500 civil penalty. Second offense. Administrative penalty. The court will suspend a defendant's license while the criminal prosecution is pending if they were found to have a BAC of 0.08% or higher. The court will also suspend the defendant's license if they had refused to take a chemical test. If the refusal is determined unlawful at the DMV hearing, the defendant's license will be revoked for a year and the defendant will have to pay an additional $750 civil penalty. Third and subsequent offenses. Administrative penalty. The court will suspend a defendant's license while the criminal prosecution is pending if they were found to have a BAC of 0.08% or higher. The court will also suspend the defendant's license if they had refused to take a chemical test. If the refusal is determined unlawful at the DMV hearing, the defendant's license will be revoked for a year and the defendant will have to pay an additional $750 civil penalty. Aggravated DWI penalties. A person is guilty of aggravated DWI if 1. They operate a vehicle with a BAC of 0.18% or more, aggravated DWI per se, or 2. They operate a vehicle with a passenger 15 years or younger and commit a DWI, drug DWI, or combination DWI, aggravated DWI with a child passenger. Compared to other impaired driving offenses, New York laws have more severe punishments for aggravated DWI. First offense. Aggravated DWI per se is classified as a misdemeanor under New York's driving laws, while aggravated DWI with a child passenger is a Class E felony. A person convicted of a first offense aggravated DWI will also be subject to the following penalties. 1. Aggravated DWI per se, a maximum of 1 year in prison and/or a fine of $1,000 to $2,500. 2. Aggravated DWI with a child passenger, 1 to 4 years in prison and/or a fine of $1,000 to $5,000. Second offense. Both types of aggravated DWI are considered Class E felonies if the defendant has been convicted of a DWI, aggravated DWI, drug DWI, or combination DWI within the last 10 years. In addition, the defendant will be subject to the following penalties. 1. 1 to 4 years in prison and/or a fine of $1,000 to $5,000, and 2. An 18-month mandatory revocation of their license. Third offense. Both types of aggravated DWI are considered Class D felonies if the defendant has had 2 prior convictions of a DWI, aggravated DWI, drug DWI, or combination DWI within the last 10 years. In addition, the defendant will be subject to the following penalties. 1. 1 to 7 years in prison and/or a fine of $2,000 to $10,000, and 2. Permanent revocation of their license, if the defendant has had 3 impaired driving convictions, refusals, or a combination of convictions and refusals within a 4-year period. 2. After 5 years, the DMV can lift the restriction if the defendant has not refused a chemical test during the 5-year period, has not been convicted of subsequent impaired driving violations during the 5-year period, can provide proof of documentation of successfully completing a rehabilitation program. Get the help of experienced Nassau County and Suffolk County DWI lawyer Edward Palermo. If you have been charged with a DWI in Nassau County or Suffolk County, we may be able to help. Experienced DWI attorney Edward Palermo has provided quality legal representation and counsel to Long Island residents charged with impaired driving offenses. At Edward Palermo Criminal Defense, our qualified DWI attorneys can conduct a strategic and comprehensive study of your case. Call us today at 516-280-2160 or 631-265-1052 to schedule a free consultation with one of our qualified Long Island DWI attorneys.